Now we are going to turn to our next speaker, Reva Siegel. She is the Nicholas Katzenbach Professor of Law at Yale Law School, where she's taught courses in constitutional law, anti-discrimination law, legal history, and transnational equality law. She holds a BA and Master's of Philosophy degrees in American Studies, as well as a JD from Yale University. Her writing draws on legal history to explore questions of law and inequality and to analyze how courts interact with representative government and popular movements in interpreting the Constitution. She is the Fellow of the American Academy of Arts and Sciences and an Honorary Fellow of the American Society for Legal History. She serves on the Board of Advisors and the Board of Academic Advisors of the American Constitution Society and on the General Counsel of the International Society of Public Law. Dr. Siegel was elected to the American Philosophical Society in 2018. And today she is going to speak to us on guns and democracy.
Thank you. Thanks to the Society for this invitation and to Bob for that introduction. So my topic today is guns and democracy. And I'm going to be starting off by thinking a bit about the reason that we regulate guns or fight over regulating guns. Of course, it's the immense harm that guns can inflict. But what kind of harm is that? Every account begins in the obscene tally of injury and death. When we think about it, we can start counting 250,000 gun-related deaths worldwide in 2019. Of them, 66% occurred in just 66 countries: Brazil, the United States, Venezuela, Mexico, India, and Colombia, with the United States having the second highest number of gun-related deaths, suicides, and homicides combined. Among high-income countries, the United States stands out for its high levels of gun violence, with firearm homicide rates per capita in the United States more than 20 times the European Union's. According to data from the Pew Research Center, 44% of Americans say that they know someone who's been shot. Yet this model measures the harm of guns by the physical harms they inflict. And today, I want to look beyond physical harms to include the social harms of gun violence in our tally. In several papers that I've published in the last year, co-authoring with Professor Joseph Blocher, I've expanded the frame to take account of the social as well as the physical harms of gun violence. And our object in exploring the social harms model, which as you hear me today, you'll see could be elaborated from a variety of disciplinary perspectives, is to make visible the threats that guns pose to democracy and to the forms of equal citizenship on which democracies depend. We believe that the physical and social stakes of gun regulation are distinct, and that the social stakes are actually evolving as we speak, that the social stakes need to be reckoned with in a debate over gun rights, especially as that debate is moving into our federal courts as it's now doing. In my talk today, I'm going to sketch some of the social harms of gun violence, which, as I've indicated, are open to interdisciplinary investigation and expansion, and then suggest a bit about how this account intersects with the evolving law of gun rights, although this part of my talk is going to be fairly skeletal. So what do I mean by the social harms of gun violence? As we look beyond the number of Americans wounded and killed by guns and begin to take account of the uncounted number of people traumatized by those shootings, we can see that even the threat of gun violence can inflict injuries without inflicting physical wounds. The case of trauma should cue us into a broader social field. Both the experience and the threat of gun violence can shape the ways that people live together. The use of guns, the memory of guns, the fear of guns, and the threat of guns all shape social relationships. So to illustrate the social model, I'll start with three linked examples. Many efforts to count school shooting victims tally the students killed, roughly 300 since Columbine. But that number grows if we add to that tally the students harmed by the threat of violence. So how do we count their numbers? For the first circle, we can look at the survivors of school shootings. Now we're up to 250,000 students who have experienced gun violence at school since Columbine. Many have psychological difficulties and perform worse at school. But what of those who have reason to fear a school shooting? Parents are now vigilant in safeguarding their children against this dread prospect. Active shooter drills are now conducted for virtually all of the over 50 million students enrolled in K through 12 school today. A recent study shows that in the months before and after the drills, 40% of the students experienced an increase in depression and anxiety. But even we put measures of anxiety aside, we could say that active shooter drills ensure that all students experience imminent shooting as a feature of their everyday school life. Okay, now consider the case of intimate partner violence. When Congress adopted the Lautenberg Amendment in 1996, which prohibits gun possession by persons convicted of misdemeanor domestic violence, Congress focused on the prevention of physical harms, and for understandable reasons. Roughly half of the female murder victims in the United States are killed by an intimate partner, and more than half of them by gun. So there are clear physical harms, and law can help prevent them. But there's a broader problem as well. Most abusers use guns as instruments for intimidating and coercing their victims, not only physically harming them. Once we recognize the threat dynamic in domestic violence, we can better understand how guns shape the public sphere more generally. So for our third example, consider the role that gun display increasingly plays in our public life, even when guns are not fired and arguably not even brandished. 15 years ago, the open carry of firearms at public protests would have been a shocking sight, but it is growing to be an increasingly commonplace sight. The practice of open carry, often by Americans in military garb, frequently masked, is now a familiar feature of demonstrations, asymmetrically and strongly associated with conservative protest. We often see arms displayed at protest, whether the protest concerns gun control, COVID shutdown orders, or racial justice. Consider the growing number of incidents in which armed protesters or the threat of armed invasions have forced the shutdown or the closure of democratic institutions, from the Michigan legislature in April of 2020 to the United States Capitol in the spring of 2021. So why bring and openly display weapons? In certain cases, protesters are bringing guns as vigilantes in the expectation that they will need to act to protect, in their view, protect life and property as substitutes for the state. Think of young Kyle Rittenhouse, now on trial for murder in Kenosha, Wisconsin. Even more often, protesters bring long arms as part of a political dispute to express political identity, to stand their political ground, as it were, and to assert their will to govern. Why else would arms be displayed at protests not involving the regulation of guns? For example, involving COVID shutdown orders or vaccine mandates or ballot audits. As January 6th suggests, Americans facing each other in disagreement are increasingly inclined to address grievance through violence. Consider the following poll. After violent attacks on the US Capitol, 30% of those who self-described as Republicans agreed with the following statement, quote, "Because things have gotten so far off track, true American patriots may have to resort to violence in order to save our country," close quote. The percentage who agreed with that statement was 39% among those who thought that the 2020 election was stolen from Trump. So considerable evidence suggests that were it not for strict gun laws in federal buildings in the District of Columbia, those who assaulted the United States Capitol may well have been armed in just the way those who invaded the Michigan legislature in 2020 were. How do unarmed citizens respond to all of this? Consider the growing number of people who may be deterred from fully exercising their rights because they felt threatened by armed individuals or paramilitary style groups. Diana Palmer and Timothy Zick report that in the past year, 1 in 6 of armed protests has turned violent, sometimes including gun violence. They conclude that, quote, the visible presence of firearms increases the risk of violence and death, and show that, quote, the increased risk of violence from open carry is enough to have a meaningful chilling effect on citizens' willingness to participate in political protests, close quote. As we're increasingly coming to appreciate, guns can threaten the exercise of constitutional freedoms. When the state regulates guns in the interest of public safety, it's not only protecting persons against risk of physical injury, it's protecting the most elemental of liberties, the freedom to move in public spaces without fear of injury, the freedom that one can come and go in the world and send one's children into the world without fear of injury. For this very reason, gun control laws can provide Americans the security to move freely in the public sphere so that they can speak, assemble, legislate, vote, learn, and worship without fear. When the state regulates guns to protect public safety, government is at one and the same time protecting both the physical person and the body politic, providing physical security on which the exercise of all our liberties depends. Including social harms of gun threats transforms the constitutional accounting. We no longer find ourselves balancing a constitutional right to bear arms against the government interest in preventing physical injury. Once we recognize the social as well as the physical harms of gun violence, we can see constitutional freedoms on both sides of the gun debate. My second point is related but distinct. I want to suggest how not only guns, but judicially enforced gun rights can threaten democratic life. Gun rights do more than insulate guns from regulation. Gun rights can threaten democracy precisely as they move debate about the proper regulation of guns away from representative government and into the courts. In remarks of this kind, I can only bring a question of this kind into view, which I'm now going to try to do with a few observations. I'm essentially going to try to put it in issue. The fact that a court limits democratic decision-making about the regulation of guns does not, standing alone, make its decision anti-democratic or even democratically suspect. In our constitutional democracy, with its long history of judicial review, we expect courts to circumscribe the decisions of representative government in appropriate circumstances. For example, we believe courts ought to limit representative government in order to enforce enumerated constitutional rights and to impose guardrails on democratic debate that safeguard equal participation, ensuring free speech, voting rights, to name a familiar few. Today, the court and most Americans assume that the court's decisions striking down gun control laws enforce enumerated constitutional rights, specifically the Second Amendment. Yet scarcely anyone knows that this view of the law is just a few years old. Until 2008, the Supreme Court had never struck down a gun control law as violating the Second Amendment. The Second Amendment states, quote, a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed, close quote. For more than 2 centuries, the amendment was understood to concern the organized militia and was not understood to concern gun control laws at all. Prominent conservatives, including Chief Justice Warren Burger and Robert Bork, confirmed the view that the Second Amendment concerned militias. In 1989, Bork explained that the Second Amendment's, quote, intent was to guarantee the right of states to form militia, not for individuals to bear arms. Not a single federal court case struck down a gun law on Second Amendment grounds for more than 200 years. But in 2008, the Supreme Court did strike down a law restricting handgun possession under the Second Amendment. District of Columbia versus Heller held that the framers of the 1789 Constitution ratified the Second Amendment to protect an individual right to keep and bear arms for self-defense in the home, where the need for defense of self, family, and property is, quote, most acute. The court's decision in Heller transformed the meaning of the Second Amendment by replacing the regulation of militias with, quote unquote, self-defense as the, quote, core lawful purpose, close quote, of the Second Amendment. While many conservatives celebrated Heller as the, quote, finest example of what is now called original public meaning jurisprudence ever adopted by the Supreme Court, I'm quoting Randy Barnett, other conservatives warned that the decision, quote, invited Americans to do what conservative jurists warned for years they should not do, bypass the ballot and seek to press their political agendas in the courts, close quote. I'm there quoting jurist Harvey Wilkinson. In brief comments of this kind, I can only alert this audience to the fact that Heller's provenance as an expression of original or framers' understanding was and remains contested. When the decision issued, I was invited to comment on the opinion and traced Justice Scalia's claims about the Second Amendment's original meaning to movements and political party conflict of the Reagan era, that is to say 20th century, in a paper I titled Dead or Alive, Originalism as Popular Constitutionalism in Heller. In the years since the decision, linguists who have reviewed data on linguistic usage of the founding era have severely criticized Justice Scalia's application of a originalist method, specifically his claims about the original public meaning of the phrase keep and bear arms. Reviewing databases with nearly 100,000 founding era texts, corpus linguistic scholars tie the phrase bear arms to military usage and reject Justice Scalia's claims that the phrase would plausibly be used to express a right concerned with self-defense in the home, disconnected from military service. In short, they also credit the militia reading of the Second Amendment that prevailed for the 200 years before the court's revision of the Second Amendment in Heller. Yet, however we account for Heller, it bears noting that the decision focused on self-defense in the home, and further that the decision recognized that the government has ample authority to regulate weapons in the interest of public safety. Justice Scalia explained in Heller, quote, nothing in our opinion should be taken to cast doubt on longstanding prohibitions on the possession of firearms by felons and the mentally ill, or laws forbidding the carrying of firearms in sensitive places such as schools and governmental buildings. This term, this coming Supreme Court term, a court transformed by President Trump's appointments is once again poised to expand the judicially enforceable protections for gun rights outside the home. It's poised to expand Heller now to provide judicially enforceable protections for gun rights outside the home for the first time. The court will decide whether the Constitution allows representative government to restrict public carry, the use of guns in public places. The court is hearing a challenge to a New York state law that requires residents to obtain a state permit to carry concealed guns in public in New York State Rifle and Pistol Association versus Bruin. After oral argument in the case, the consensus is that the court will strike down the New York licensing law as affording state officials too much discretion in awarding gun licenses, with much speculation that some coalition of conservative justices will extend the reach of the judicially enforceable right to self-defense into the public sphere with carve-outs for so-called sensitive places. To finish up, as we know, Americans differ greatly in the importance they attach to gun rights. A recent Pew poll showed that gun owners and non-gun owners alike rate many rights, freedom of speech, the right to vote, privacy, freedom of religion, virtually identically, and attach them nearly supreme 100% importance. But gun owners and non-gun owners divide in the way they value the right to own the right to own guns, with gun owners ranking the right to own guns at 74% and non-gun owners ranking the right to own guns at 35% in importance. Pew reports other notable differences. About 8 in 10 Black adults say gun violence is a very big problem. By comparison, 6 in 10 Hispanic adults report the same, and only 4 in 10 white adults view gun violence this way. In democratic politics, voters can mobilize and seek laws embodying their differing views of these matters at the national level or in their states and cities. But as the court expands the footprint of Heller, the court is poised to override the democratic process and enforce what appears to be a gun owner's understanding of gun rights on other Americans. As it does so, the court is likely to reach for legitimation in signs and symbols of the deep past. The justices that President Trump appointed favor methods of interpretation associated with the text, history, and tradition, in which a jurist decides what gun regulations are constitutional by analogy to past practice. Whatever its constitutional warrant, the method is riddled with unavoidable indeterminacy, shifting discretion out of the political branches and into the federal courts, and focused on issues of judicial legitimacy having little to do with the question of guns as they would present in democratic debate. In my view, we need to reckon with the ways that guns are shaping our wounded 21st century constitutional democracy with our eyes fixed firmly on the present, and with a willingness to engage in the tug of war and haul of democratic debate. We will find out next June what space the Supreme Court will allow us for that crucial conversation. Thank you.
And thank you for this very powerful and, should I say, scary talk. I'm waiting to see what other questions may come through here, but right now, let me just add something based on my own thoughts and experiences with respect to the social harms of the widespread availability of guns. In recent discussions of incarceration, I've seen mention of the effects that incarceration has on the families of the incarcerated. Now, you referred to school shootings, but I can tell you that as a member of a family in which two young people have killed themselves with guns, I can tell you that there is great harm to families over time from the misuse of guns, from their excessive availability as well. And that too is a social matter worthy of comment.
Can I just say that the numbers on suicide are spectacularly high. They well exceed, I mean, the greatest 66%. The preponderance of gun-related deaths in this country are suicide deaths. And it's with the increasing availability of guns, those numbers are rising. And there are interesting convergences between groups concerned about suicide and the gun violence groups now. It's because, while many suicide attempts, there's an opportunity for intervention. With a gun, there's less of an opportunity. And it's a huge, huge issue.
Yes, thank you very much. Ruth Cowan asks, what hope do you see in an effort to amend the Second Amendment?
We have in Article 5 a very onerous amendment process. And for that reason, the prospects of a constitutional amendment are, in every case, quite difficult. And given the present distribution of opinion on guns, I would say they are even more remote. I think that it's an interesting feature of our politics, but there's interesting conjunctions between conversations around guns and abortion. I think my mind just went there. Many Americans think that abortion should be available but regulated, and I think that many Americans think that guns should be available but regulated. And I'm not sure in what ways. I'm not sure that we would ever agree on an amendment. And I also think that the forces arrayed against change would be mammoth, given the difficulty of even modest regulation of guns. But I'd be interested in hearing any other thoughts on that question.
Thank you. Linda, we're going to wrap up now with a question from Linda Greenhouse. who asks what you think the implications are for the court. I assume she means the Supreme Court, as an institution, if and when it rules in this area against the desires of a majority of the public, and especially Americans of color.
So I'll take that in several steps. So as Linda knows, I do focus a fair amount on the ways in which the court interacts with political parties and mobilized groups in various of its decisions, which does lead me from time to time to focus on issues where there is the formation that I sometimes refer to as asymmetric mobilization. What do I mean by that? The gun case is a really beautiful example where one side is fiercely organized, and then there are many parties who are interested on the other side, but they're less well organized than gun rights owners are. There's growing organization, but the organization is not nearly as, not even remotely as well organized. When it comes to the question, I'm not sure what will happen if the court really unleashes an opinion that prevents localities from regulating in a significant way. It's now, as I'm sure Linda would say, deeply uncertain how far the court is going to go in the Brune case. The oral argument leaves a lot up in the air about where the court is going to move in this opinion, how far its decision will go, how narrow, how broad. How that decision will be received within communities of color is even more complex question. There's fascinating division and conversation around the issue of guns and race today. And it appeared in the briefing in really striking ways. Because we live in a racially stratified society, race appears in the enforcement of gun laws in a big way. Most of our laws, to our great grief and regret, or my great grief and regret, are enforced in racially salient, if not racist ways. And that happens in the area of gun control often. There was a public defender's brief that came in making that point and called for the expansion of gun rights as a consequence. There were briefs that came in rebutting that argument, saying that communities of color would be terribly harmed by the expansion of gun rights. Right now, the death rate is higher within communities of color, which shows up in that Pew polling that I read in my talk. Yeah. So I could imagine, I don't think that the response would be univocal, nor should it be within communities of color if the court were to expand gun rights. But I do think that there is growing engagement with this issue, and I'm looking forward to it getting taken up in more systematic ways. I think that there needs to be. We can expect Justice Thomas to speak to the issue in the strikingly Black nationalist ways he often does, but only on the side of gun rights. And I'm looking to hear about the race conscious response in more dimensions as the court's opinion issues. I believe it's critical that there be such a response. I don't believe that the equities are on one side of this case, certainly given the levels of violence and the kinds of harms that will occur with unregulated guns hitting the streets in urban centers. I don't want to take the group's time, but I am deeply concerned about the effects of the court deregulating through a Second Amendment strategy in the way that appears to be coming down the pike.
Thank you very much, Professor Siegel.